Hi, welcome back to Legal Time with Connaughts. My name is Anna Rana. I'm a solicitor advocate with Connaughts. To my left is Awais Javed, solicitor at Connaughts, and to his left is Sharia Khan, senior lawyer at Connaughts. Today we'd be discussing a few questions in relation to different topics, mainly substantial judicial review hearings and Tier 1 extension applications and Tier 1 applications. My first question is for Sharia. Can you tell us something about your substantial hearing, which is due to take place on the 10th of October, and I understand it's on the issue of whether a human rights application can be made without an application, whether a human rights claim can be made without an application?
Yes, I mean, we're quite excited about that. We talked about it in the last show as well. And essentially, the crux of the case is that we are arguing that a human rights claim, the key word, of course, is claim and not an application, that a human rights claim can be made without actually paying the Secretary of State a fee or filling out a form. So it's quite an important case, of course, and then we dwell further on whether what's the difference between a claim and an application. But all said and done, it can be a huge case this year if we actually do proceed with the case and we're successful. Of course, I say if only because we are presently still negotiating and perhaps we might set this matter. But of course, if this case continues, then we'll update you probably in our next show as to how the matter is progressed, or you'll hear about it otherwise on the news. So yes, I'm excited about that, and let's see how that proceeds.
Okay, great. Moving on to another matter, jail substantial hearing for Awais. I understand that there is a jail substantial hearing which possibly has been settled on the issue of whether asylum can extend PC leave.
Yes, it was another case we were initially very excited about, but luckily it's been settled. It's a good news for our client. Initially, the issue was whether asylum claim made in time extends to a 3C leave or not. Now, Home Office has this historic position that once you have claimed asylum, even though at the time of making that claim your leave to remain, you still had leave to remain, your 3C leave does not continue, and if you make a subsequent long residence application based on your 10 years long residence, for example, then obviously your long residence is broken. And we took that issue further, and eventually Home Office, we were granted permission at an oral hearing, permission hearing, and eventually Home Office agreed, and we settled by consent that in our client's particular case, asylum will extend her 3C leave. The important point is they have confirmed that in writing to us that they will be agreeing that 3C leave will continue, which means it can be used for, not as a reported case of course, but it's something that we can use in other matters as well. So in case anyone has claimed asylum and they still had leave to remain and they still face that issue of whether their leave to remain continues or not, then this is something we can help them with. This also raises another important point, whether if you had a right to work before claiming asylum, whether that right to work continues or not. If your 3C leave continues, essentially what it means is your previous status continues. So if you had right to work previously, does that continue or not whilst you're claiming asylum? We have had a lot of cases where Home Office has agreed to amend ARC card, which is the initial card for asylum seekers, where they have allowed them to work. So it's a very good news for a lot of people.
Okay, and a lot of people do ask, can judicial review actually extend PC leave?
Well, no, I think we've been always talking about this as a hot point for 3C matters. And a judicial review definitely does not extend, as far as the Home Office's position is concerned on this matter, it does not extend 3C. So I would ask applicants to be wary. A lot of applicants, unfortunately, suffer at the crux of this wrong advice, because what happens is that they perhaps have been in the country for a certain period and they require a certain more period to stay here lawfully. And they believe that as long as the matter is under judicial review, that the period of residence is lawful. I suppose the argument is that it's lawful, but it does not go towards 3C, it does not extend to lawful residence in the UK. So although the Home Office cannot remove you, which gives clients confidence, it doesn't mean that your residence is lawful, it doesn't mean that it can accrue towards a certain period, let's say the 10 years residency. But of course, Oasis' case, I just wanted to add, is absolutely, again, a huge case, because there was nothing really in the immigration rules or in the case law to say what happens to 3C when you make a claim for asylum. But the obvious point, I guess, that everybody was missing so far was is that asylum still is a claim to the Home Office. It's still an application to the Home Office, and there should be no reason why that should be differentiated. So I think since time age that the position that the Home Office would take was wrong, and this could be very helpful to many applicants.
Okay, thank you. We also get a lot of phone calls where clients do say that they've had a particular period of leave that is not a period of leave where the leave has finished and they've been an overstayer, they've overstayed for a period of time. Now, can you give examples of when periods of leave are a bar to be considered as part of a long residence group?
I think the present rule, the new rule is that if you overstayed for more than 14 days, then that would normally break your continuous residency. So the example would be that if an applicant had an application refused with the right of appeal, then they become appeal rights exhausted at one point when they've exhausted both the appeals. And if they're looking to make a fresh application, that fresh application needs to be made within 14 days. Similarly, if an application is refused with the right to an administrative review, a fresh application again needs to be made within those 14 days. So that would be the only thing that would guarantee, once the second application is successful, that your lawful residence is not broken. Staying beyond that means your lawful residence is broken.
Mm-hmm. And what if you've left the country?
Well, of course, if you've left the country, then I don't understand the question. So,
I mean, as in if you've left the country and you've had leave,
yes.
and then you want to come back but your leave's expired, is there a possible route there onwards? Or?
Well, the key point there is that you must leave the country with lawful leave. So if you leave the country again within that 14-day period, then unfortunately again there's a misunderstanding there. That does not permit you then to come back within a month. The rule is that you must leave while holding leave or 3C leave. So I guess if that answers your question, you must leave the country with a visa or with leave, 3C leave.
I mean, just to add to that point, like Shiva said, the most important point to consider is that at the time applicant leaves the country, they must have leave to remain in the UK. So, for example, if someone is going through an appeal process, as soon as they leave the country, in-country right of appeal is automatically withdrawn unless it's under EU regulations. So, once they have left the country and they have leave to remain, they have to either come back within 6 months with that leave to remain, or if their leave to remain expires whilst they're outside of the UK, they will have to make an application within 14 days. And once that application is granted, they will have to come back to the UK within 6 months, then their 10 years long residence is not broken. Now, another point here is that if once you have left the UK, let's say you had 1 month remaining, and you go back, you make an application straight away, you're granted leave to remain, and you come back within 6 months, absolutely fine, no problem. But if you can also wait up to the point where leave finishes, and you have 14 days to make the application out of country and place application. And once visa is granted, you will have to come back within 6 months of the date you left the UK with a valid leave to remain. In that case, your 10 years long residence will not be broken. So these are the scenarios. I think your other point was, we were discussing it previously as well. So for example, if someone's, let's say, 3 months short of their leave to remain, 10 years long residence, and their appeal rights are exhausted, so they put in an application, like you said, within 14 days using an exception under 39E. And whilst that application is pending, they finish their 10 years long residence. What would be your view on?
Well, that's still again a grey area with immigration rules, because what we argue is the date of decision is the relevant date. So if somebody's made an application and they've not accrued the full lawful requirement of 10 years in the country, they made an application when they were here, let's say, with this example, for 9 years, 6 months, and the Home Office is likely to refuse that application because you've lawfully only been in the country for 9 years and 6 months. Because when you make the application, you're taking benefit of the 14-day rule, but that 14-day rule is a concession, it's not a visa. So it doesn't mean that your 3C is being extended. So which means that the Home Office is likely to refuse an application if an application is made within the 14 days and you've still not completed 10 years. Best case scenario in such cases is, of course, to complete 10 years lawfully, either in the application process by holding leave and or in an appeal or an administrative review. But we are arguing the point and we are in court on this point to argue that the date of decision should be the relevant date. And if we are successful on that point, then it doesn't matter whether you had completed 10 years on the date of application, but it's more important that you should have completed it when the caseworker decides the application. But that still has to be decided.
I mean, if you look at the rule itself, I think it's 276B, part 5, I think, don't quote me on that. I think one of the parts where this exception is mentioned under 39E, someone puts in an application, the only way this exception is applicable is when they don't have leave to remain in the UK.
Okay.
So when they put in an application and that application is pending and they're finishing 10 days on that, one thing is clear, like we discussed previously, that their 3C leave does not continue because the application is put in out of time.
Okay.
But what I sometimes struggle to understand is why would there be an exception to the rule where you can put in an application and then not be considered as part of your long residence once you have finished your long residence with the same application?
I guess in Home Office's defense, what they would say is that if it was an application which did not fundamentally require as a rule that you be here 10 years, so let's say you submitted a student application, so then they do not penalize you if you submit an application within 14 days, even if they take a decision after 6 months, they will approve it. They won't hold the fact that you overstayed against you. But the trick is with the 10-year application, as OS mentioned, the paragraph 276B specifically requires you to be here lawfully 10 years. And that's where the trouble begins in this particular route.
And lawfully definitely means that you have to have leave to remain.
With leave, yeah. I mean, again, that's an argument that if you had a judicial review, you were here lawfully, but they actually require leave.
Thank you for that. Moving on to Tier 1 applications. Now, a lot of clients have noticed that Home Office has a restriction on the amount of absences you can have when you leave the United Kingdom. Question is that we get a lot of these questions by clients: how many absences can you have? And what if they exceed those absences?
Sure, so it's a good thing that you asked me this question because just dealing with a complex case this morning where the applicant believed that they were within the 180-day period, and of course after a substantial investment, you bring in £200,000 into the country, you create jobs, you pay taxes, and then at the end of it all they realize that they've actually not been staying here for as long as they're required to. So my advice to applicants A is don't use this visa, don't use this concession so strictly that you're just calculating your days and thinking, oh, I'm here 170 days, 175 days. A lot of applicants actually do that because if they're high-flying entrepreneurs, they're traveling a lot. The trick is, that the problem is that the Home Office A calculates this in two different complex ways. One would be the old rules, as I would call it, and they would just calculate it on a reverse way. So if you make an application today, they calculate it on a year-to-year basis and they work backwards towards 5 years. But then there's the new rule which came into play on the 5th of January this year, which is calculation on the basis of rolling basis. So that means that they calculate in a forward manner. They don't typically only calculate backwards. If at any time you exceed 180 days in a forward calculation, they also could refuse your application under that rule. Now that rule is again applied in a different way. If only you've been granted leave extension for Tier 1 under the new rules, which is after 5th of January 2018, then the new rules apply to you and they calculate your absences on a rolling basis, and they also take into account the absences of your dependents. So it's so complex, as you could gather from this short summary. My advice is, if you're on a Tier 1 visa, stay here for as many days as possible and don't be so close to the border where you might risk having been refused. That's one thing. The requirement as for the Home Office, of course, is 180 days. So in a given year, you cannot be outside the country for more than 180 days. The calculation is where it gets tricky, so have a lawyer monitor this for 5 years so you're sure that you will qualify. And one other thing that applicants definitely need to be aware of is that they think if they stay on for 1 more year, they will be eligible for nationality. Now this is again like an elephant in the room that the Home Office never actually openly disclosed this, but the requirements for nationality law have always been 90 days in a year. So although you might qualify by this 180-day calculation to get indefinite leave, you will not by that same calculation be eligible for nationality law. I mean, you would agree with that, wouldn't you? Like the nationality law definitely says 90 days a year. So the best thing for Tier 1 applicants really is 90 days a year. Don't exceed that, and that will ensure that you're safe within the 180-day rule and you're safe within nationality as well.
Okay, thank you for that. Now, for the applicants who are on a Tier 1 general visa, if they finish the 5 years, can they vary that to a different route?
Tier 1 entrepreneur, right? So with the Tier 1 entrepreneurs, it's possible.
I think we have a similar question here as well. To do with if you're on Tier 1 entrepreneur visa and you apply for extension, for example, after 3 years, and by the time Home Office considers that application, you finish your 5 years. So can you vary it to indefinitely? So you can add that as well.
Yeah, this point was clarified again in the last statement of changes which came through the 5th of January. And yes, after 5th of January, if you made 5th of January 2018, to be specific, if you made an application for an extension, but in the meanwhile you've completed 5 years, then you can vary your application and apply for indefinite. This wasn't possible before. There's nothing in the rules actually on this point before, but the 5th of January statement of changes have clarified that you're now able to vary your application and go directly towards indefinitely.
Okay, thanks for that. Now, we have received a lot of questions that applicants are the understanding that they can make an application within 28 days, which means prior to them actually qualifying their date. Is it the case saying the naturalisation application, is that the same case?
In last 20 days of the qualifying
period, yes.
Okay. Well, as a general rule, if you're qualifying, for example, indefinitely, for that matter, any extension application, you can make an application in the last 28 days of the qualifying period, but it does not apply to naturalization applications. You have to finish your time period. So, for example, if you are, generally speaking, it's 5 years you have to stay in the UK, and you have to finish those 5 years before you make a naturalization application. If you make in the last 28 years, then you have not qualified under the Nationality Act for living in the UK for the last 5 years. And another important point is that this also includes the day your 5 years period starts, you have to be in the UK. So, for example, you go backwards, and when you finish your 5 years, going backwards from the date of application, you're not present in the UK at that time. For example, you were out on holidays, even if, for a week or whatever, you still don't qualify. So it's from the date you were present in the UK 5 years onwards at the time of application.
So if someone were to make an application today on the 5th of October, so 5 years back, on this very day, you need to be in the country.
That's correct.
Although the 5 years will work differently if you calculate it very strictly, but I think they typically look at
the 4th of October. You have
the 4th or 5th of October back in 2013, you will need to be in the country.
Okay. Are there any other questions which you two possibly get on numerous occasions which you think possibly needs to be addressed?
Well, I think sorry.
I just wanted to ask you to clarify a bit more regarding the hearing that you have now. So, because it's a very important issue for a lot of our clients who cannot afford to pay Home Office fee and they want to make a human rights claim. So they make a claim on papers. Previously, we could submit a Section 120 notice. Now even that has to be, Home Office has to invite you for
yeah, I mean that's where the claim arose from, really, not to go into the fine details of the case, but the applicant had made a human rights application at one point. So what we are saying is not that it's unlawful per se for the Home Office to have a requirement to pay a fee and fill out a form in human rights applications, but what we're saying is that there should also be a provision that if you're making a human rights claim, that it can be done without paying the fee. And what we don't mean to abuse the process, what we mean to say is that many applicants have, as always suggested, made a paid application to the Home Office at the expense of £4,000-5,000 for a family. That application has been refused. Now, once that gets refused, in many cases the applicant is eligible under, classic example would be that they've now completed, their children have completed 7 years in the country, so they want to make an application under the relevant immigration rule to say, actually, now you need to take this into consideration, that our children have spent 7 years in the country. It engages an immigration rule, and reference has to be had to that as well. So when we make another application to the Home Office in the form of a claim, in the form of a notice to tell them that this has happened, Home Office will typically refuse that application and say make another paid application. So it's absolutely draconian to expect applicants to pay another £5,000 or £4,000 again for a family to bring or entertain a fresh claim. Another case that I was recently doing, quite a compassionate case, is of trying to draw an analogy with other dependent relative. A 75-year-old mother is in the country. So we made an application, and the end conclusion by the Home Office was that she can return and adequate care can be provided by the family sending money back home. But meanwhile, she just had an accident a couple of weeks ago at home, and that's changed the entire, the angle of the case, because now the case is way more compassionate. She needs 24/7 care. And when we raised all of these matters again with the Home Office, and what they've come back to us with is that although the case will be made very compassionate, you need to make a paid application again. And the client just paid them £2,000 just a few months back. So why would they again need to make a paid application? They should be considered as a claim. So that's the long and short of this matter really. It's going to develop, and we'll see how the Home Office defends this, and we'll see how the court looks at this. But we will fill you in our next program as to how this went.
I mean, one of the arguments Home Office always brings up when the issue of payment is raised with the new application is that there are provisions already under the immigration rules to make an application as a destitute of a fee exemption application.
Correct.
But we have noticed from our experience as well, and Anand has made a lot of those fee exemption applications, the criteria is, even though it's written down, it's very arbitrary. We get fee exemption on cases as compared to those where we don't, where Home Offices refuse, they deserve it more than the ones that they've allowed fee exemptions for. And the criteria for restitution, for example, and even if they're meeting their rents, they still have no money to pay these huge application fees and health surcharges, and Home Office still won't grant them fee exemptions, even though they cannot afford to pay.
Yeah, I mean, correct. And that's why we are not even, as far as the legalities of our case is concerned, we are saying we don't even need to get into destitution, and we don't even need to start looking at the forms as to what's the prescribed way to justify why they cannot pay the fee. We are saying it's a question of law and not affordability. And the law does not, as far as the European Court of Human Rights is concerned, Article 8 is concerned, that the law does not simply require in this particular case for us to pay a fee, fill out a form to make a human rights claim. It can be done in any way in any fair way that the Secretary of State may prescribe, and the present mechanism is not the fair way.
Thank you.
Unless we have any live questions.
Okay, thank you so much for that. That was very insightful. If you guys do have any questions, please do call our offices, and first consultation is free consultation. You can speak to Sharia, you can speak to your mates, anyone, and yeah, otherwise you can email us as well and we get back to you. Other than that, I guess we call it a wrap for today then. Alright? See you next time. Thank you.